If you are gearing up for the bar exam, you know that some rules of law aren't just things to memorize. They are tools, they are weapons. Today, we're diving deep into one of the absolute cornerstones of evidence law, the rule in Jones v. Dunkel. Get this right, and you can literally turn an opponent's silence into one of your most powerful arguments.
So, put yourself in this situation. The one person, the only person who really knows what happened, simply refuses to get in the witness box. The facts of the case are messy, the evidence is thin. What do? How do you, as the advocate, spin that silence into a win? That's the exact puzzle we're going to unpack in this explainer.
All right, so here's our roadmap. We'll start with the fatal accident that kicked this whole thing off. Then we'll look at the bombshell moment in the trial. From there, we'll see how the High Court sorted it all out, which gives us the rule itself. And really importantly, we'll wrap up with the limits you absolutely have to know for your exams. So let's get into the facts. Okay, our story starts on a dark, wet night way back in 1953 on the Hume Highway. The scene is, well, it's grim. Two big trucks have collided. The driver of one, a Mr. Jones, is dead. The other driver, Mr. Hegedus, is hurt, but he's alive. The problem is, the evidence at the scene was, as the court later put it, vague and meager. Just not a lot to go on. And this is where the physical evidence gets really, really weird. The truck of the driver who died, it's on its correct side of the road, right where you'd expect it. But the other truck, Hegedus's truck, which was supposed to be traveling south, well, it's found behind the first truck, and it's facing north. How on earth does that happen? It's done a complete 180, but there are no skid marks, nothing to explain it. And that is the absolute heart of the problem here. The physical evidence just creates more questions than answers. The plaintiff, Mr. Jones's widow, has to prove that Hegedus was negligent. But with facts this confusing, how could a jury ever get past just guessing? This brings us to the trial itself. So the case goes to trial. The plaintiff lays out all of this confusing evidence, and then all eyes in the courtroom turn to the defense. And then, in a moment of pure courtroom drama, the defendant's lawyer just stands up and says, "We won't be calling any evidence." That means Hegedus, the only survivor, the one person who could possibly explain how his truck ended up facing the wrong way, is going to stay silent. Now this is the moment the whole case turns on. A juror who is clearly wrestling with this puts his hand up and asks the judge a direct question. He wants to know, hey, can I hold this guy's silence against him? The judge's answer wasn't very clear, and that very question is what sends this case rocketing all the way to the High Court of Australia. So now the High Court has to give a final, definitive answer to that juror's question. And let me tell you, their answer has been echoing through Australian courts ever since. And the court was actually split. On one hand, you had Chief Justice Dixon, who dissented. He basically said, look, the plaintiff didn't prove their case. Without the defendant's testimony, it's all just guesswork. Case closed. But the majority? They saw it differently. They said, no, there was just enough evidence to make an inference of negligence possible. And the defendant's silence? That's a key piece of the puzzle in deciding whether to actually draw that inference.
So let's break that down, because this is the crucial part. Justice Kiddo, writing for the majority, explains it perfectly. He's saying the silence doesn't invent new evidence out of thin air. But if you already have some evidence that points towards an inference, like a truck being in a very strange position, the defendant's failure to get up and explain it away allows the jury to draw that inference more confidently. His silence makes the plaintiff's existing case strong. Justice Menzies made it even more practical. He broke it down into a clear 3-step guide. First, you can't use silence to plug a hole in your evidence. If you have no case to begin with, you still lose. Simple as that. Second, the evidence you do have becomes more believable because, well, the other side had a chance to contradict it and they didn't. And third, and this is the real money shot, if the facts already make an inference of fault possible, the defendant's silence is a circumstance that helps the jury take that final leap and actually draw the inference.
Okay, so we've gone through the history. What does this all mean for you, the advocate, getting ready for court or for your exams? This is where we boil it all down to the black letter law.
you need to have in your back pocket. So here it is, the rule as we know it today. An unexplained failure to call evidence may lead to an inference that the evidence would not have assisted that party's case. Now, notice the careful wording here. It may lead to, not must lead to, and it would not have assisted, not would have been damaging. These little nuances are everything.
So as an advocate, this is your toolkit. This is what the rule lets you do. You can stand up in court and argue that because your opponent didn't call a crucial witness, your evidence should be accepted more readily. You can argue that the inference you've been pushing for, the inference of negligence, should be drawn more confidently. It's a massive tool of persuasion.
But, and this is a huge but, you have to know the limits. You cannot use this rule to patch up a case that's full of holes. It does not turn a wild guess into a solid fact. And this is critical. You can't argue that the silent witness would have been a smoking gun against their own side. The only inference allowed is that their evidence just wouldn't have helped. If you misstate that in court or on an exam, you're going to have a bad time.
Okay, time for the advanced class. To really smash this on an exam, you need to know not just what the rule is, but when it doesn't apply. These are the exceptions that can make or break your argument. Now, this is a classic exam trap, so listen up. The rule we've been talking about, it's for civil cases, like our car crash. In criminal law, it's a completely different ballgame. The accused right to silence is sacred. A judge will almost always specifically tell a jury not to draw a negative conclusion from an accused person not testifying. A Jones v. Dunkel direction is incredibly rare in a criminal trial. You have to know that distinction. And here's your practical checklist. The rule is off the table if there's a good reason the witness isn't there. They're sick or their evidence is privileged. It also doesn't apply if the witness isn't really in one party's camp. Think of an independent expert who's available to both sides. It's also no good if their evidence would just be repeating something we've already heard. And, of course, if there's no real case to answer in the first place, then there's nothing that needs explaining away. So let's end with this thought. Jones v. Dunkel is so much more than just a rule of evidence. It's a deep insight into strategy, into persuasion, into human nature itself. It forces you, as an advocate, to think tactically. When you're preparing a case, always ask yourself, what story is my opponent's silence telling? Because sometimes the most powerful thing in a courtroom is the evidence that's never even given.